in touch and speak to the Member of Parliament for Boko Central, the Honorable Mahama Ayariga. Good evening, sir, and thank you for joining us.
Hi, good evening. We are about to start the hearing in relation to the second nominee. Let's be snappy about it.
Right. Quickly, I just want to find out from you that is this the best platform to have raised this particular matter? Couldn't you have done this at plenary when the Speaker made the recommendation to the committee?
I think that I can raise it at any stage. I can raise it during the hearing of the vetting, and then I can raise it at plenary. I can raise it whenever the opportunity arises to raise it, and I did that, and I believe that it has gotten all of us as a country discussing this issue in relation to our constitution and what is actually the proper step. I'm sure lawyers will be discussing it. Sure, the president's attention will be drawn to what has transpired, and I believe that also future presidents will also be mindful of what has happened today. And then we'll force ourselves as a nation to sit down and then rethink what we have been doing wrongly.
Was that the actual intention, to get the attention of the president and, of course, other stakeholders to this particular matter?
Oh, yes, that's my intention. My intention is to draw attention to the fact that what has been happening is wrong. A lot of people who call me agree that it is wrong, but everybody has always assumed that the president has the authority to just keep deciding what number he wants. But if you read the Constitution carefully, you see that there's nowhere that it is said that the president has that authority. The Constitution is actually silent about who decides the number. But then there's another constitutional provision that says that when there's a silence like that, that space is supposed to be filled by Parliament. So Parliament should enact a law determining that matter. So I think that the president should think about it. We'll raise it on the floor because this matter is not going to end now. It will go back to plenary. The committee's report will go back to plenary, and all that has happened at the committee will be captured in the report, and it will be debated, and the issue will come up again at plenary.
What was it your expectation or how it turned out? Was this how you were expecting it to turn out when you raised the matter of the constitutionality of the powers of the president to appoint more than 9?
Well, I mean, I raised it because I wanted it to get attention. And I think that the way that our colleagues went about it was what gave it all that attention, because even though I moved the motion, on our side, we knew that we didn't have the numbers to win the vote on the motion, because once you move a motion and the numbers are equal, then, the motion is lost. So why they were even struggling to prevent the matter from being put to a vote, surprised us, because we kept drawing the attention that they had the numbers. So why were they afraid to put it to a vote? Because it is only procedurally right that once a motion has been moved, it is put to a vote. And again, you have the numbers to win the vote. So why are you forcing that the matter should not be put to a vote? So it is their insistence on avoiding a vote that really, I think, also escalated the situation. Otherwise, I believe that would have taken note of the point, would have moved the motion, would have taken the vote, would have lost the vote, and would have continued, and would have probably finished voting them earlier.
Is it that there is a lapse in the Constitution where it allows for the appointment or sets the number of Supreme Court justices at not less than 9 in addition to the Chief Justice, but does not place a bar on the maximum number of Supreme Court justices to be appointed? And is it that presidents who have done these appointments have allocated these powers to themselves when actually it should have been Parliament that would have to enact laws to address this lapse?
Yeah, that exactly is my argument. My argument is that the Constitution in Article 128 simply says that the court shall be made up of 9 judges plus a Chief Justice, making them 10. That should be the minimum. Now, it doesn't say anything about the maximum. It doesn't say anything about who determines the maximum. And then in 144, it says that the president shall appoint the judges in consultation with Council of State and on the recommendation of Judicial Council and then with the approval of Parliament and all that. It doesn't also mention the determination of the upper limit. So the president is not given that power to determine the upper limit. It just says that he should appoint judges. So we are saying that under Article 298 of the Constitution, there's a provision that says that anytime that there's a matter in the Constitution that has arisen, for which no provision is made anywhere in the Constitution, then Parliament shall enact a law to deal with that matter. So our argument is that the upper ceiling issue should be the responsibility of Parliament from time to time. So at the time when we said we're moving from 10 to 12, Parliament should have enacted a law saying we now want it at 12. When we decided that it should be 15, Parliament should have enacted a law adjusting it to 15. And I said that even if people say that the president has a discretion, then once you introduce the word discretion, it means that he's exercising a discretionary power, and we must bring it under Article 296 of the Constitution. And 296 says that where the president is going to exercise a discretionary power, then he must act in a way that is fair, reasonable, and candid, and he must enact a constitutional instrument to govern the exercise of the discretion. So the president should have brought a constitutional instrument to Parliament saying that, look, I want to expand the Supreme Court to 15. So this is the notice. And then it will go through the processes of enactment as a constitutional instrument. And then, when it goes through the 21 days notice and MPs cannot mobilize 2/3 to abort it, then it becomes law that the Supreme Court's upper limit is now 15. Then he can now nominate and then we'll get. So tomorrow if somebody wants to, let's say any president comes and thinks that the number should be 15, all he needs to do is to bring a constitutional instrument. And if he has his numbers in Parliament, it will pass. And then he will now make the appointment up to the 20. The same way, if the person feels that it should be an act of Parliament, all he needs to do is to introduce an act of Parliament and a vote by simple majority, and then the law is passed, placing the ceiling at 20. If you go to India, that's what they do. The Indian Supreme Court is similar to the Ghanaian Supreme Court in jurisdiction, in everything. And there, the Indian Parliament always passes a law increasing the number. Originally, the Constitution said there should be 7. But today, India has 33 Supreme Court judges, and that was enacted by Parliament, that the number should be 33. Of course, there are 1.4 billion people. We are just 33 million people. For me, it is not even the issue of the number. In fact, people are misconstruing my position. My position is not that 15 is too much. No. To tell you the truth, I have no position either way about the number, whether it's too much or not. Those who are involved in administrative justice should always recommend whether they think that the number should increase based on the caseload and etc. But then I'm saying that whether you want it to be 15 or 20 or 25, just go through the laid down constitutional procedure. Don't make it a one-man show that the president of Ghana can do whatever he wants. So he can wake up any morning and just think that the number should be this, and then he just announces. No, I think that the Constitution is clear on the procedure for doing these things, and we must hold presidents accountable to the processes.
Honorable, would you then admit a failure on the part of Parliament to have allowed this to happen over the years?
Yeah, that's true. Parliament has failed. There's no doubt about that, all of us. But then I said better late than never, even though we've allowed these transgressions to have occurred over the years. There's never, a problem with trying to get the right thing done and then positioning your country better in terms of its constitutional practice.
Well, these two nominees are actually, per the letter of the president, to fill a vacancy that will be created from the retirement from retirement of some current judges, Supreme Court judges. This will not necessarily add to the number, will it? It will only be a replacement. Is that not correct?
Well, if they retire, the number is increased to 30. If you are replacing, you are now increasing it back to 15.
And this is what you say will be constitutionally wrong.
Anything above 10 is constitutionally wrong without a legislation or a CI.
It appears from proceedings today at the committee level, there was some level of unanimity with this particular argument or assertion that you made. However, the challenge was with whether or not the vetting should proceed. Would that be correct if I say so?
I mean, that was because I moved the motion that we should terminate proceedings and refer the matter back to the Speaker. But then a motion was taken and then we lost the vote. So that's how come that we continue with proceedings.
Well, the majority MPs on the committee seem to have a challenge with your position regarding a motion at the committee level. Is this the normal process?
Well, I mean, I think that there was some misunderstanding of the rules. You know, we have new rules, and so not everybody is conversant with the new rules. But I think that ultimately they came to understand the new rules. I think also that, you know, they were just unnecessarily apprehensive because if they had paid attention, they would have known that based on the new rules, there was no way we were going to even win the vote if they had put the matter to a vote. So when they understood it and put it to a vote, clearly we lost because we didn't have the numbers.
And the new rules and, of course, everyone...
I have to get back into the committee.
Right.
The vetting of the second person has started.
Right. Honorable, thank you so very much. And, of course, we're taking that vetting live as well, but grateful and we wish you all the best. Thank you so much. The Honorable Mahama Ayariga,